Okay, hello everyone. So we can get started. So thank you very much for joining us. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. So today we are going to talk a little bit about what are some of the ways an E-2 investor can move to a green card. So just a few things before we get started. Scott Legal is a full-service immigration law firm. We are able to assist whatever your immigration needs may be, including employment-based visas and family-based visas. As some of you may know, the firm was founded on an E-2 visa, so visa options for investors and entrepreneurs are our specialty. We will be continuing this webinar series, and we are doing at least 2 webinars a month on a variety of immigration law topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you a PowerPoint that has all the information covered in this webinar. We will also send you a comprehensive guide covering all the visa types that will be discussed in this webinar. We will also send you a link to where you can sign up for additional webinars coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be available on YouTube, and we do encourage everyone to subscribe and hit the notification button as we do upload regularly a variety of videos on immigration law topics. Finally, we will send you a link to where you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further with us. So today, we are very lucky to have LeGrand Weiner, managing attorney of the firm, who has a wealth of experience in assisting investors and entrepreneurs in a wide variety of visa categories. Finally, for any questions you may have, please feel free to add them to the chat box or the Q&A function, and we will try and get to all questions. So without further ado, let us get into some of the common questions we get about the visa options for E-2 investors moving to a green card. And so just as a quick introduction and to bring everyone up to speed about E-2. So Kelly, could you go over what is an E-2 visa?
Of course, absolutely. Thank you, Jiyae. And yeah, so an E-2 visa is an investor visa that allows a treaty country national to come to the United States and develop and direct a company. So this is a visa that's not for people that want to kind of, be a passive owner, but someone that actually wants to actively run the company. For an E-2, you need to make a substantial investment, and what is substantial will depend on the type of company you're setting up. So for a service-based company like a law firm or a consulting firm, you may be able to invest what we'd say a lower investment amount, maybe somewhere around $100,000, given that you have low startup costs. Whereas if you're starting up a company like a restaurant or you're starting a manufacturing plant, the investment may need to be higher to be considered substantial because the startup costs for those types of businesses are higher. So it will depend on what type of company you're starting. Besides a substantial investment, you need to show that the company or the investment is at risk and irrevocably committed. So that means the money has to actually be spent. If this is a scenario where you're purchasing a business, then you can put the money into escrow, conditioned only upon the approval of the E-2 visa, and then the money would be transferred to the seller. So besides a substantial investment, you must show that the company will be real and operating. So in a startup scenario, you would show that you have the website set up, you have your office space, you have your equipment, perhaps you've hired an employee, you've gotten your licenses in place. So everything necessary to kind of get the business up and running. The business cannot be marginal, which means it must make an economic impact or have the ability to make an economic impact within a 5-year period. The way that you show a business is not marginal is you produce a 5-year business plan and show that the company will hire employees. If you're purchasing a company that's already running, ideally they would already have employees. So you would show proof of that. For the investment funds, you need to show that there's a legitimate source of the funds, so that the funds come from, somewhere that is, not a criminal or illegal enterprise of any kind. The money can come from a gift. It can come from a personal loan that's not secured by the assets of the E-2 business. And then finally, the E2 is a non-immigrant visa that does not specifically allow for dual intent. So you also need to show that you have an intent to depart the United States if or when the visa status ends. We'll talk a little bit more about that later in the presentation, because it is still possible to be on an E2 and apply for a green card, even though the E2, technically does not have that dual intent aspect. But we'll talk a little bit more about that later.
Right. Thank you for that overview. So Kelly, then what would be some of the reasons why some people may want to move from an E2 visa to a green card?
Sure. So I think, one thing about the E2 is that it is renewable indefinitely. So there's some visa types like the H-1B and the L-1 where you kind of will max out at a certain number of years. But the E2 is not like that. You can renew indefinitely. And so for sometimes you have people that maybe they've been here for a very long time and they decide, now I'd like to permanently live in the US. I've been here for long enough. My business is going well. And depending on which country you're from, you may need to be renewing your E2 visa as frequently. Some countries only get a visa stamp for 3 months. Many can get it for a few years, but the maximum is 5 years. Some countries, it's only 2 years or 18 months or 12 months. So in that scenario, sometimes people want the green card because they don't want to always be having to renew, the E2 visa. They want that security that they'll be able to live and work in the US permanently. Additionally, for the E2, the company does need to be majority owned by treaty country nationals. And if you're the investor, you need to own at least 50% or have operational control over the company. And it may be sometimes as a company grows, maybe you're bringing in new investors, maybe you're bringing in new owners, and you're worried about your ownership dropping. So the green card would solve, that as well. Ultimately, the green card, it's an attractive option for many people because it just gives you much more flexibility in your employment. You can run your E2 company and you could also work for another company, or you could start another venture and not have to worry about, kind of more of the narrow requirements of the E2. Another reason people might want to move to a green card is perhaps they're here with their children. And, especially if you have a 5-year visa and you're kind of renewing it 1, 2, 3 times, perhaps your children are growing up in the United States. So people sometimes like to get to the green card so that their children have the ability to live and work in the United States, if that's their choice, as otherwise, once the children turn 21, they can't get E2 dependent visas anymore. And now they would have to, get an F1 student visa or find some other option, or perhaps depart the United States. So that's another big reason.
I see.
And then as well, if you move to a green card, you eventually would have the ability to naturalize and become a US citizen. So if somebody, is really committed to their life in the United States, that's something that, is an attractive benefit.
Definitely. Those are very, very good points. So, okay, then. So how does the green card system work in the US, if you could provide an overview? And in particular, does the US use a point-based system for obtaining green cards, as I know some other countries use?
Right. So some countries do have a point-based system. The United States does not have a point-based system. So it's a different system. Basically, in the United States, the way that it works is that a certain number of immigrant visas, which are the green card, are allocated each year in various categories. So you can apply for a green card based on employment. You can apply for a green card based on a family relationship. You can apply for a green card based on humanitarian relief. There's also some other programs like the diversity visa lottery that grant green cards, to people that are in countries that traditionally do not immigrate to the United States in large numbers. So it's not a point-based system. It's based on kind of one of these particular, types of categories: investment, employment, family, humanitarian. And then within each category, there's a certain number of visas allocated. And then there's a certain number of visas allocated based on the country where the person was born. So the system is, I'd say, relatively complex in that sense. We're all, when you look at the visa bulletin, this is something that the Department of State and the government issues each month to tell you how many visas are available in any given category in any given fiscal year. And so it's based on kind of those numbers, country of birth, and category that you're in, and how many visas were allocated to that category.
Right. So the waiting time to get a visa could really differ based on what country you were born in.
Absolutely. Yes.
Right.
And
That's a very
unfortunately,
important
there's, yeah, in many,
consideration.
in many situations, there's kind of long backlogs,
Right.
you know, for Indian and Chinese, you know, people that were born there. One caveat is just if you have an immediate relative family petition, then a green card is always available to you. You're not subject to those, you know, numerical limits.
Right. So then this can be a good way to segue into, one of the first categories I wanted to ask about, which is what are some of the common types of family-based green card petitions do you see when people are moving from an E2 visa to a green card?
Sure, absolutely. So, you know, I think one very common thing we see is sometimes people are here and they meet someone and they marry a U.S. citizen or they marry a legal permanent resident. So that's kind of one very common way, you know, that people might, someone here on an E2 might transition to a green card. Also, sometimes people may have kind of long dated family preference petitions pending. So maybe a sibling petition, which, you know, takes a very, very long time, or perhaps they have a parent here and they're, you know, a married adult child, you know, or a married adult, you know, who has a parent who's a U.S. citizen. So sometimes there's kind of a long pending family preference petition that was filed many, many years ago, and the person is here on the E2 while that petition, while the priority date becomes current, and then they're able to adjust based on that. You know, I'd say those are really the two most common, you know, situations that I see, although, you know, certainly others can exist.
Right. That makes sense. And so then about the application, the process of applying for a green card itself. So what are the differences between consular processing and adjustment of status?
Sure. So adjustment of status, I think that, you know, if you're already in the United States and you primarily live here, your family is here, you know, your kids go to school here, your spouse works here, the adjustment of status is usually going to be, you know, the option that you will take. And the way that that works is you file a form called I-485 with U.S. Citizenship and Immigration Services. Once you file that, you can also file concurrently for work and travel authorization. You know, those petitions, the work and travel authorization sometimes can take, you know, several months, a very long time. While you're waiting, but while you're waiting for the green card to be adjudicated, if those get approved, then it allows you to work, you know, in the United States. It allows you to travel internationally, and then you can continue to renew those the work and the travel authorization for as long as your green card application is pending. You know, one thing with adjustment of status is that once you file it, unless you're in an H-1B or L status, you cannot travel. So if you're here on an E-2, you file an adjustment of status, you now cannot travel outside the United States. You would need to wait until your travel authorization is approved, and then you could use that to travel. And then you would really no longer be on E-2 status. You would be, when you came back to the United States, you would be paroled in and be in a period of authorized stay based on the pending adjustment of status. So for people that need to travel frequently for business and really can't have that period of time where they're just kind of stuck in the United States for 6, 7, 8 months waiting for this travel authorization, consular processing might be better. So for consular processing, that's a scenario where your immigrant or, you know, visa petition is approved, your I-140 is approved, your I-130 is approved, and then the approval is sent to the National Visa Center. So then you send all of your biographic and green card application documents to the National Visa Center. They'll review it and make sure everything, you know, looks good, and then they will send it to the U.S. Consulate where you most previously resided. After, you know, let's say you're in the United States on your E-2, wherever you resided before you, you know, moved to the United States, that's usually the consulate they'll select. You know, you can, depending on kind of if you have permanent residency somewhere else, or if it, you know, sometimes you can kind of ask them to change it. But definitely a good thing to consider is, you know, will you be able to go to that country? And then once the application is, you know, is complete and the consulate has availability, they'll schedule an appointment. You'll attend an appointment, and then if your application's approved, they'll put an immigrant visa in your passport. You have to enter the United States within usually 6 months. That's usually how long the immigrant visa is good for. And then your green card will be mailed to you once you enter the United States.
Right. How long does this process usually take for either option?
So unfortunately, especially right now, this process is one that is, you know, at best case scenario, many months, and, you know, generally more like a couple years. In particular, consulates, are still dealing with the backlog from COVID. There's still many immigrant visa petitions that were kind of really just put on hold during COVID when the consulates really shut down. And those are continuing to work their way through the system. So both on the side of adjustment of status and consular processing, you're likely looking at a period of a few years, before you actually have your green card in hand. This is why if somebody, really primarily lives in the US, that's where they want to be. Often an adjustment of status is going to be the route that they go, because that's really what allows you to stay in the United States, for the entire, long pending process.
Right, definitely. And so can someone work then while their green card application is pending? Since, we talked about how long this process can really take until you get your green card in hand.
Right. So this depends. It really depends on what status you're on. So let's assume that you're on an E-2 and you filed your adjustment of status application and you still have a valid I-94 for a couple more years. So as long as you're continuing to work for your E-2 company, yes, you have underlying status, you have an underlying work visa status, and you can continue to work. Let's say you get travel authorization approved and your work authorization is not approved yet. They're now doing these applications separately. And you travel outside the United States and you come back, on advanced parole. At that point, you're no longer in E-2 status and you would not be able to work until you had a work authorization document approved by USCIS. In some circumstances, you are able to work and you are eligible to apply for work authorization. And once you get that in hand, you're able to work. But depending on what status you're in, there may be some gaps or periods of time where you cannot work. Or let's say, your E-2, you file your adjustment of status and then your E-2 I-94 expires, soon after that. And you don't have your work authorization document yet. At that point, you should not work until you have your work authorization document. So you would need that kind of underlying status that allows you to have work authorization, or you need the work authorization document to have been approved by USCIS in order to work.
Right. That is why careful timing would be a very important factor when you're applying for a green card.
Yes, absolutely. So, Jiyae, I'd like to switch and ask you a couple of questions.
Sure thing.
I think that we've talked about kind of family-based options. We've talked about but I also want to talk about employment-based green card options. And in particular, which green card category is the most popular when someone wants to move from an E-2 visa to a green card?
I would say self-petitioning for an EB2 NIW, a national interest waiver green card petition, is one of the most popular options for among E2 entrepreneurs. And there are some reasons why this is the case. So first of all, the EB2 NIW petition does not require a job offer from a U.S. company. And also, compared to EB5 category, which is another popular category for E2 investors, the EB2 NIW tends to be a little bit more accessible because it does not require the applicant to invest any money, and the processing can be much quicker. So applicants can now use premium processing for the EB2 NIW and get a response on their I-140 application within 45 days. So to qualify for the EB2 NIW, applicants must prove that they meet 3 criteria set up by a case called Matter of Dinosaur. And so the first criteria is that the applicant's proposed work in the United States must have substantial merit and national importance. And the second criteria is that the applicant themselves must be well positioned to advance this work. And the third criteria is that on balance, it must benefit the United States to exempt the applicant from going through the labor certification requirement. And in practice, to say generally, the national interest waiver can work well for entrepreneurs who have developed something innovative that is important to the field or an industry as a whole. And I think it strengthens the petition if that industry or the field is something that the US government is particularly invested in, such as particular types of technology or a cause such as environmental sustainability or veterans welfare or things like that.
Perfect. And so let's say, so you mentioned the 3 criteria from Janazar. So can anyone who meets those 3 criteria qualify for a national interest waiver?
So unfortunately, no. each applicant also needs to meet the threshold test to qualify under the EB2 category in the first place. And the EB2 category is for individuals with an advanced degree or exceptional ability. And let me break that down a little bit. Advanced degree here means a master's degree or above. So for example, a master's or PhD would clearly fit, but this also includes, degrees like a JD, Juris Doctor, an MD, medical doctor, or MBA that requires a bachelor's for admission. Now, there is also another way you can meet the advanced degree threshold, which is by showing that you have a bachelor's degree in your field and 5 or more years of progressive work experience after you received your bachelor's in the same field. And that can count as you having the equivalent of an advanced degree in your field. Now, so let's talk about exceptional ability then. So if you do not have a master's degree or its equivalent, you could also qualify for the EB2 threshold by showing that you have exceptional ability in your field. And you can show this by meeting at least 3 out of 7 criteria for exceptional ability. We do have particular webinars that talk about each of these criteria. So I do encourage you to encourage everybody to check out our other resources on meeting this.
Perfect. So you mentioned that it's possible to self-petition for an EB2 NIW. Can you talk a little bit more about what that means and why that might be really advantageous, particularly for E2 visa holders?
Right. So the applicant can self-petition for the green card using the EB2 NIW category. And by that, it just means there is no need for a U.S. employer to sponsor the petition. And in other cases, you do need, if you don't qualify for the NIW, if you want to just qualify under the general EB2 or EB3 employer-based green card category, you do need a U.S. company to be the petitioner who is backing up the petition. And this can be very advantageous for E2 investors because they typically have majority ownership in the company that they are working to direct and develop, right? And unfortunately, if you have such majority ownership in that company, you cannot use that company to create the job offer, basically, to sponsor your green card through one of these employer-sponsored options. And this is because the government would know that, will think that the job offer is not really a bona fide job offer because you cannot really be objective when you're basically issuing a job offer to yourself. So the EB2 NIW provides a very good way for investors who have ownership interest in a company to really sidestep that requirement and self-petition for the green card.
Perfect. Thank you. I do see one, someone asked a question of, can you ask questions? And yes, we will get to questions at the end. Yeah.
Right. Definitely. Yeah, we will definitely reserve some time to answer those questions. Okay, so maybe now then let's shift gears, Kelly. And I wanted to ask you about what is called the $1 million green card, the EB5 investor green card petition. So many people do confuse E2 visas with the EB5 $1 million green card. So maybe could you talk a little bit about that and how one might move from an E2 visa to a EB5 green card?
Sure, absolutely. So yeah, I think this is a really common misconception, when you talk about the E2 investor visa and people say, well, I don't have $1 million to invest. And, so there's kind of similarities, but there are, important key differences. So obviously the E2 visa is a non-immigrant visa that, temporary, needs to be renewed. The green card, the EB5, you would get a conditional green card and eventually be able to remove those conditions and live and work permanently in the US. In terms of the similarities and differences, so both of these visa types require investment and both require job creation. However, the E2 does not have a set investment amount that is required. You just have to make a substantial investment, and what is substantial is going to depend on the type of company you're setting up. Similarly, you need to create jobs, but you don't have any particular number of jobs you need to create. But for the EB5, you do. So for the EB5, there are investment requirements. You have to invest at least $800,000 or $1,050,000, depending on if you're in a targeted employment area or not. Additionally, you have to create 10 full-time jobs. So it's, so those are kind of some very key, I think, important differences, between the E2 and the EB5. In terms of the, other requirements, like both have a source of funds requirement. So for each one, you have to show a legitimate source of funds. However, for the EB5, the requirement is significantly heightened. So much, much more extensive in terms of the amount of scrutiny they'll apply to the source of funds requirement, and also some particular, extra requirements in terms of what you're allowed to include as investment or not. So for example, if you are an E2 investor and you purchase a business, the amount that you pay to the seller is your substantial investment. However, for EB5, that does not work. For EB5, there has to be a nexus between the investment and the job creation. And so if you pay money to a seller to buy a business, that's not going to work for EB5. For some people, you will, I think going from E2 to EB5 is something that we certainly have clients that have done this. Often in that case, the investment is made over time, and it's kind of a complicated area. So you do want to work with a qualified immigration lawyer if that's your plan, is to go from E2 and then slowly invest into EB5. Because if you're doing that, like let's say that you want to only invest 800,000 in a targeted employment area. So each time that you make the investment over the years, the entity has to be considered in a targeted employment area. So if your office moves over the years or it moves between locations, that may be an issue. You also want to consider that any investment you make has to come from personal funds. It can't come from business profit. It cannot be retained earnings. And there's other fees that just don't count for EB5. So administrative fees, legal fees. So that's just to say that, if you are on an E2 and your plan is to try to eventually get an EB5, you really want to start talking to a qualified, EB5 immigration attorney before you start making those extra investments, because you want to make sure everything you invest can actually be counted.
Right, that's very important. Point that you made there. It could be a good idea for those clients to reach out to a qualified EB5 immigration lawyer before spending more money into the business.
Yep, absolutely.
Right. So with regards to the application process then, so what would be the process of applying for an EB5 green card? And are there any timing related considerations?
Certainly. So in terms of the petitions that have to be filed for the EB5, the relevant petitions are, so one is the I-526. So this is where you provide, the proof of the source of funds, the proof of your actual investment. The next step is the I-485. So that's the green card. So the I-485 is adjustment of status, or you could go through consular processing like we talked about earlier. And then the final step is the I-829. And this is the form you file to remove the conditions on your conditional green card. And when you file this, you have to show that you've sustained your investment and also that you've created the 10 full-time jobs. Otherwise, they will not remove the conditions on your green card. In terms of timing, right now the I-526 is taking 3 to 4 years. The one good change in the law is that if you're in the United States in a valid status, you now can file the I-485 concurrently with the I-526. So previously this was not the case. So even if you filed your I-526, it gave you no benefit. You basically just had to wait for several years. However, now you're in a position where you can concurrently file the adjustment of status. You can file for work and travel authorization. So at least while you wait, you're also getting work and travel authorization. The I-829 is then filed 2 years after you get your green card. So your conditional green card will expire in 2 years, and kind of in the 90 days before that expiration, you file your I-829. This is also taking about 3 to 4 years to process. So it is quite a lengthy process for the EB5. One thing I just want to mention is that, there are mechanisms to speed up processing of petitions. For some of our clients who've had really, really long dated petitions, we've successfully used mandamus, which is a filing in court where you're trying to compel USCIS to make a decision on your petition. So it's not right for everybody, but it certainly is, I think, a good option, if you're in a situation where your petition has been pending for years and years and you really, need that response.
Right.
Yeah. So I wanted to transition a little bit and talk about maybe some other green card options. We've talked about, the NIW, we've talked about the, the EB5. We've talked about family petitions. So what if the E2 client has some type of extraordinary ability? What type of green card might be appropriate for them?
Certainly. So yes, let's talk about the EB1A green card for extraordinary ability individuals. So in some cases, we do see a client is so well known in their field and is really recognized in the field as one of the front runners, right? In such a case, self-petitioning for an EB1A green card, it can be an option, which is for, as I said, individuals of extraordinary ability. So, for example, let's talk about if someone, an entrepreneur who is actually famous for having led a multi-million-dollar IPO for the first time in their industry, in their country, for example, that is certainly a leading accomplishment that could result in someone having that degree of recognition in their field, in the field of business. So for clients then like that who have achieved sustained national or international acclaim, such that they can be characterized as one of that small percentage who have risen to the very top of their field of endeavor, those clients can certainly try petitioning for self-petitioning for an EB1A green card. And in general, I would say the EB1A really works best if the client can provide a substantial volume of evidence that their achievement have already been recognized in and have been widely recognized in their field of endeavor. And so there are certain categories of required evidence to qualify for an EB1A category. Either you should show a major one-time award such as a Grammys or a Nobel Prize, but in the most common way to meet this is to show 3 out of 10 types of evidences, and those types of specific evidences that the USCIS is looking for include such as receipt of lesser forms of awards, media articles published about the applicant and his or her work, participation as a judge of other experts in their fields, playing a leading or critical role in distinguished organizations, and membership in selective organizations that require outstanding achievement among their members. So if you are operating in that high level in your field, such that you could show sufficient evidence meeting some of these criteria, the EB1A could certainly be an option you could explore.
Perfect. And so is there ever a scenario where the E2 company can sponsor like the E2 investor or the E2 investor's family members for a green card?
Yeah, so that is a very common question that we get, and we did sort of touch on this earlier, but the answer is no. Unfortunately, that will not work. In the employment-based green card sponsorship process, there is a specific question whether the prospective employee has any ownership interest in the sponsoring company, or is there any familial relationship between the person being sponsored and any owners, stockholders, officers of the corporation. And if that's the case, the company will not be able to sponsor that employee for the green card. And this is because the government will assume that the job offer will not be objective. But let's say, though, an E2 investor, for example, has a spouse who is in the US, and keep in mind that E2 spouses can work for any employer in the United States. And let's say that E2 spouse is working for a different company that is not the E2 entity, and that third-party company wants to sponsor the spouse for a green card. In such a case, that is a case that will actually work. So. And in that case, if the spouse is going to be the beneficiary of the green card application, the whole family can join. So that is one way we have seen this work.
Absolutely, absolutely. And so we've talked about EB1, EB2, NIWs. Are there any other kind of green card options for e-visa holders? Could you just quickly summarize kind of the top ones?
Sure thing. So we have seen sometimes E2 visa holders enter the diversity green card lottery. So every year there is a lottery you can enter in October, and the results are announced in May. And that is one way we have seen clients move from E2 to a green card. And this is also a little less common, but there are some humanitarian types of visas. For example, if you had witnessed a crime, there is a visa for that. And once you move to that, you can transition into a green card based on those as well, but a little less common to see.
Sure. So let's talk about, we touched on this briefly before, but so the E2 visa is a dual intent visa. So can you talk about how that works with the transition to a green card?
Right. So is an E2 visa a dual intent visa? So technically the E2 visa is not a dual intent visa. So the visa holder must always show that they intend to leave the United States upon the expiration of the E2 visa. So applying for an immigrant petition can complicate this to a degree, right? So timing is very important when you are applying for an immigration benefit. So if your E2 is expiring soon, for example, and if you're preparing to submit an I-140 or an I-130, it could be beneficial to extend the E2 first and then apply for the immigrant benefit. But having said that, there has been some policy announcements specific to the E2 that say that in practice, USCIS has been okay with E2 visa holders maintaining E2 status even after applying for an I-140 and sometimes even after applying for an I-485. So it is definitely a good idea to speak to your lawyer to figure out what the risks are in your particular situation.
Perfect. And so let's say that somebody's here and, they think maybe EB2 NIW, maybe EB1A, we're not really sure. Can you
Right.
apply for more than one type of a green card at a time?
So the answer is yes. It is possible to have more than one green card petition pending at the same time. So for example, one client could have an EB5 petition filed and pending for a long time, but also apply for an EB2 NIW at the same time that is pending, and whichever one gets approved, then you would adjust status based on that approval. Similarly, a client may have an EB2 NIW pending, but also apply for an EB1A if they can qualify. So yes, you can certainly apply for more than one type of green card at a time.
Perfect. So I think those were all the questions that we had, but it seems like we have some questions that have come in. So I think I'll take this first one, and then
Sure.
Jay, I think I'm going to ask you some of these others. Somebody's asking, if you get an adjustment of status approved for E2, can you go visit Canada to get an E2 visa? I'm assuming that you mean a change of status. An adjustment of status is a specific term for transitioning to a green card. But if what you mean is a change of status, then yes, you can be in the United States, get a change of status approved to E2, and then you are able, so the consulate in Canada, not every consulate will allow third country nationals to apply there. Canada will allow third country nationals when the person is residing in Canada or is residing in the United States. So if you're on an E2, you're residing in the United States, yes, you can attend your E2 appointment in Toronto. One thing to consider is that depending on what country you're from, you may need a Canadian visa. So you want to plan ahead for that, just to make sure, because just the fact that you have an appointment at the consulate in Toronto does not mean Canada will let you in unless you have a proper visa for Canada. So Jay, there's a question here about F1 students in a PhD program and asking about whether they can apply for an NIW. What are your thoughts?
Yeah, so if you do already have a master's degree, right, so you do meet the advanced degree threshold for the EB2 category. So there is nothing preventing you from applying for an EB2 NIW petition. I would say the challenge here, if you are still in your PhD program, is how are you going to prove that you are well positioned to advance the endeavor which you're proposing, and also this would really depend on the type of endeavor you are proposing to do. So let's say you're proposing to engage in research, and you will be filling a gap in the industry by offering your original insights to a field. So in order to really make a good case, you need to be able to prove that you are well positioned to have that impact in your industry. And how would you prove that? If you are shooting for a research related endeavor, you do need to show a track record of success in that research. So this will really depend on what kind of record you have. If you have already published research that has been cited by independent researchers widely in your field, if you have given a lot of presentations in conferences, and if you can show that other researchers have already relied on your work that you have published in the past, that can certainly be a case that you can give it a try. So this would really depend on the facts, but being in a PhD program doesn't prevent you from filing an NIW because you already have the master's. You do already meet the threshold. How long should I wait with an E-2 visa or status to apply for NIW? How many years would be reasonable? Now, if you're wondering if you need some time to develop your company or develop your business before applying for NIW, it really will depend on your individual business plans and how much growth have you been achieving in your business and how much work you have done to sort of develop that proposed endeavor that could rise to the level of national importance. So there is really no minimum or there is really no formula that we use for this. We have seen clients apply several years after they have the E2 and transition into an NIW, or even just over a year. So it really depends on your individual, the progress of your business and what your proposed endeavor will be. Should I also take this one?
Yes, yeah, absolutely. I think it's kind of similar.
Oh, it is the similar one, yes.
Yeah.
Yeah, how long after being admitted on an E2 visa can an investor file for EB2 NIW? Well, one thing that you really want to be careful of is every time you enter on a non-immigrant visa, you are representing to the government that you don't intend to immigrate to the United States, right? So we do recommend waiting at least 90 days before taking an action that is inconsistent with that non-immigrant intent, right? So you don't want to just come in as an E2 and then the next day apply for an NIW. Certainly, I would not recommend that you do that just because there is that non-immigrant intent piece.
Perfect. So I can talk briefly on this next one. So someone's asking about EB1C. So EB1C is another green card option that's available to multinational managers or executives. You see it more in the context of people that perhaps came over on an L because the L requirements, the L is a non-immigrant visa, and then the EB1C is a green card, and the requirements are quite similar, not exactly the same, but very similar. So for the EB1C, there has to be a qualifying relationship between a company abroad and a company in the United States. The applicant has to have worked for the company abroad for at least one continuous full-time year out of the past 3 years in a managerial or executive role, and be coming to the United States to, be in a managerial or executive role. So it is possible to get a green card, through the EB1C. It is also possible, let's say you came on an L and perhaps then you transition to an E2 employee visa or something like that. It is still possible to apply for the EB1C. You don't have to be on an L. It's not a prerequisite to apply for the EB1C. So if there is a situation where there is, companies, related companies in both countries, and you can meet that requirement of showing that you had, you were a manager or executive abroad, and now you are a manager or executive in the United States. That's something to consider. There's no requirement for how large either of the companies need to be, but you do want to keep in mind that the government takes a very rigid view of what counts as a manager or executive. And so if neither company has a significant number of employees or the volume of business is not that high, it can be harder to prove that you actually meet that very rigid, definition of manager or executive. In terms of this question about helping an individual and assessing an E2, so I would encourage you to go to our website and set up a consultation, and we'd be happy to speak to you about any of your questions. So for this question, will USCIS see an issue with the spouse of someone who has been approved for an E2, apply for an EAD, and then have a so if you're talking about a situation where a spouse is working in an E2 spouse is working in the US and the E2 spouse has an independent employer who's sponsoring them for a perm, that's fine. So the only things to consider, I think, are that the E2 is a, not a full dual intent visa. So in terms of, the timing of when you file certain, aspects of the green card application, you may want to just be mindful about that. You wouldn't want to necessarily file an I-140 petition and then go apply for your renewal the next day. So you just want to be thinking about that, when you apply, but that's fine. It's something that, that can be done. On an E2 crossing the border daily from Canada, can I apply for an EB2 NIW without any negative impacts? So I think similar to kind of what we've already talked about, I think that it is possible to continue, it is possible to file the I-140 and continue to cross. On the I-140, you would indicate that you plan to consular process. There is, I think, some risk that, especially if you're crossing every single day, you're going to be dealing with a lot of different border officers. You can always get an aggressive officer who feels that filing the immigrant petition is an indication that you, have immigrant intent. And depending on the content of that conversation with them, if they feel that you no longer meet the non-immigrant intent requirement, they could always, have the discretion to refuse you entry. So I think there is, I think it's low risk, but there is some risk, particularly if you're crossing the border every single day. That being said, if you're crossing the border every single day, I assume it's because you have a pretty, a residence in Canada, so you have those proof of ties. So I think low risk, but you want to kind of prepare for those questions at the border.
Definitely.
Someone's asked, do I need to change to L1 first? Again, I'm not sure what the context of this is. If it's talking about EB1C, no, like you can do an EB1C, from you don't need to change to an L.
I can
so
take
Jiyae,
this one.
I'll have this one for you. Yeah.
So yeah, for the 3 criteria of NIW, if someone already has a master's of science, a few publication and active involvement in research societies, ongoing PhD, does the situation seem good for moving forward to apply? Well, it really is a fact-specific inquiry, right? And it will really depend on what your proposed endeavor will be in the future as well. If it's for a very compelling area that the U.S. government thinks is very time sensitive to address, for example, and also a challenge, as I said before, with another fact pattern is to show how you're well positioned to support this research, given that you are an ongoing PhD student. So it will really depend on what traction you have seen in your past research in the past. So I would definitely, set up a consultation with us. We'll be happy to look through your resume, look through your Google Scholar, and we'll be able to give you a more informed assessment on that. Can an NIW applicant's spouse, who is also F1, file along? So yes, like many other green card, all other green card categories, the NIW green card, you can have your spouse join the petition. If you also have children under 21, they can also join the petition, so the whole family can get a green card through this. Okay. Do you want to take the last one, Kelly?
Sure. So for this last one, so if you go to the consulate in Canada and you already have your E2 change of status approved, yes, you still have to prepare a brand new application to submit to the consulate in Canada, and they will assess it as a brand new application. So they do not have to rely on the approval of USCIS. This is different than, for example, an H1B or an L, where you get an approval from USCIS and then you go to the consulate and they're essentially going to, not re-adjudicate the petition. That's not the case for an E2. Getting an approval with USCIS is completely separate than your application at the consulate. So when you went to the consulate in Canada, you would need to produce all the documents to prove you meet the E2 requirements. And just because you were approved with USCIS does not mean the consulate will approve you. So you do want to take every step to make sure your application at the consulate is as strong as possible.
Okay. So I think we answered all of the questions. So thank you everybody for attending, and thank you, Kelly, for sharing all of your insights. And we can close. I hope everyone has a good day.
Thank you so much. Have a nice day.